Without much further ado, thank you for bearing with us. Sophie and I are going to talk to you this afternoon about pre-action disclosure and the duty of candour. And we're very grateful to Selina Plowden QC as well, who's provided significant input into this afternoon's talk. We've got quite a lot to cover, so do bear with us. We'll try and leave questions until the very end once we've managed to take you on our whistle-stop tour through the wonderful world of disclosure. So I'll hand over now to Sophie.
Thank you, Kriti. Now, this webinar focuses, as Kriti said, on pre-action disclosure in clinical negligence cases. And what we're going to do is we're going to briefly introduce the statutory context and the available methods for accessing health records, investigatory documentation, personal information held by organisations, and other documents held by public bodies. Now, these statutory methods, of course, need to be borne in mind in order to properly advise any client as to the potential for availability of documentation and disclosure obligations at the pre-action stage. So we'll start with the statutory context. We'll then turn to consider the duty of candour and the ongoing cultural shift in the medical profession towards increased public transparency, which itself then impacts the availability of disclosure at the pre-action stage. We'll also go on, of course, to examine the important pre-action protocol and pre-action disclosure rules. Part of our focus today will be on highlighting and discussing how the law deals with competing principles and rights, considering particularly issues of the importance of public transparency in healthcare as against proportionality of disclosure, and then issues of confidentiality, and how the courts weigh these issues when applying their discretion in relation to pre-action disclosure applications. We're going to have a look at some case law. I'm going to see what guidance we might derive from the case law to guide us in our own practice going forwards. And then what we'll do is we'll move to consider some examples of particular types of record and how disclosure relates to these. So first, over to Kriti to discuss the statutory access routes to healthcare records.
Thanks, Sophie. So I've set out on the slide there for you the 4 key statutory access routes. I'm sure you're familiar with them already, but they're all there in one place. So of course we've got the GDPR and the Data Protection Act 2018 for living patients, the Access to Health Records Act 1990 for patients who have died, Access to Medical Reports Act 1988, where reports have been prepared for insurance and employment purposes, and then the Freedom of Information Act 2000. If we just move through, thank you. So I'm going to start by briefly going through what we mean when we say, when we use the term health records. So there is a statutory definition under the Access to Health Records 1990. Apologies, I've just spotted a typo there for the word access, but forgive me for that. This, of course, sets out that it's quite a broad definition. So a health record is a record which consists of information relating to the physical or mental health of an individual who can be identified from that information or from that and other information in the possession of the holder of the record, and has been made by or on behalf of a health professional in connection with the care of that individual. So you'll see it's perhaps a broader definition than people tend to assume, and this applies to requests for a deceased person's records, so requests that are made under the Access to Health Records Act 1990. And then, of course, briefly looking at the GDPR and the Data Protection Act. Now, we're pretty well versed, I think, with obligations under GDPR, and of course, it could be a whole talk on its own, but there's a wider definition under the GDPR, and that is personal data is any information relating to an identifiable person who can be directly or indirectly identified, in particular by reference to an identifier, and that includes health data. So I've set that out on there for you. But the key point to remember as far as pre-action disclosure is concerned is that although patients have a right to access their own health records under the GDPR, this is subject to certain safeguards. So as the DPA sets out, the exemptions to disclosure include where providing subject access to information about an individual's physical or mental health or condition would be likely to cause serious harm to them or to another person's physical or mental health condition, or where supplying a patient with that information would involve unreasonably breaching another individual's confidentiality without their consent, and that consent is forthcoming. So again, those exemptions are for requests made under the DPA 2018. Now, I've talked about statutory routes to getting data, and most of the time, of course, in clinical negligence cases, when disclosing notes to a patient, it will not be under those statutory routes, but under the pre-action protocol, which we're going to talk about. So the reason to remember that is that disclosure for those purposes is controlled by the court rules and not the GDPR. So, and we're going to be looking at the court rules later. And the court made that very clear under Dunn and Durham, which Sophie will talk about. Hang on.
Sorry.
No, that's okay. We'll go back.
Go.
Thank you. So before we look at those rules under Dunn and Durham and the CPR, we want to consider the culture of disclosure within a background of the duty of candour. So over to Sophie for that.
Now, the duty of candour, I think, Kriti, you were going to speak to this aspect.
I'm talking about it. My apologies. It's when we split up our slides, and I've completely missed that this is one of mine. But yes, the duty of candour is a statutory duty under Regulation 20 of the Health and Social Care Act 2008, and this places a duty on regulated health and social care providers to act in an open and transparent way with patients or their representatives. So every individual clinician, whether doctor or nurse, is subject to the guidance issued by their regulators. And there's also guidance from the CQC, which has the power to take action for breaches of the duty. So for example, last year, the CQC issued its first fine against a trust on the basis that it was slow to inform a family that there had been delays and missed opportunities in the treatment of their child. Now, the duty of candour is defined as set out on that slide in front of you. So registered persons must act in an open and transparent way with relevant persons in relation to care and treatment provided to service users in carrying on a regulated activity. Now, a brief note here on Wales. There's not enough time for us today to go through the new Welsh duty of candour in any details, but what I will say is that the Health and Social Care Quality and Engagement Wales Bill has been passed. It's now received royal assent, and effectively the aim of that bill is to institute, amongst other things, to institute a duty of candour on NHS bodies in Wales, requiring them to be similarly open and honest with patients and service users as soon as they're aware that things have gone wrong. More guidance on that will follow, more detail will follow. Obviously, things are slightly slowed down because of the current pandemic, but it appears to be bringing Wales very much in line with England as far as the duty of candour is concerned.
So what's the impact of the duty of candour on pre-action disclosure? Now, as clinical negligence practitioners, we have to navigate this natural tension between this increasing culture of transparency within the medical field and then the limits on the nature and extent of pre-action disclosure imposed by the very important legal concept of proportionality. Now, on the one hand, you have a duty of candour. Duty of candour informs. It informs at both an individual and an organisational level, both at the time of treatment and afterwards. It's enshrined in professional standards, so all your clinicians, the GMP guidance for doctors, the NMC Code of Conduct, the NHS Constitution, and within the serious incident framework, and now the new patient safety incident framework as well. So the effect of all this, as we well know from a legal perspective, is to increase the number of disclosable documents and the potential weight of pre-action disclosure. Now, pushing against that is the court control of pre-action disclosure and the long enshrined principle of proportionality. There are, of course, limits on the nature and extent of pre-action disclosure. And as we'll explore, the aims of the duty of candour and the aims of the legal process are in fact in tension. So moving to consider the several areas, at the time that the duty of candour was brought in, there were concerns raised as to the extent to which it and its aims might be hampered by the legal process. There is, as we will all recognise, a principled policy argument that the extent of publication of such candid disclosure at an individual or organisational level should perhaps be to some extent limited in order to allow a safe space for the very full, frank, open type of disclosure that you really need to drive a positive safety change. And this concern has very long been articulated by the clinicians. The Royal College of Surgeons report back in March 2014, Building a Culture of Candour, a review of the threshold for the duty of candour. It's an interesting report to look at, to consider the background to the duty of candour. Now, within this, a specific recommendation was made by the authors to encourage the government to consider how it can ensure that the legal system is most able to support a duty of candour. In particular, they highlighted at that stage it could be helpful to minimise the possibility that explanations given as part of that process of candour or open disclosure are then used in evidence to support an admission of negligence. However, as we know, in fact, the tendency has instead been a push towards wider disclosure. For example, where initially the expectation on the face of it is that where a serious incident review was taking place, there would be disclosure only of the final report. So that's where we started from. Things have now developed, though, such that it's now expected under the pre-action protocol that the underlying documents that form the basis of the serious incident review will also be disclosed. Now, the cultural drivers behind this are well set out in a case we're going to look at in some detail, a recent first-tier tribunal case of Hill and Information Commissioner. It's a 2020 case, and we're going to explore it next. It's a really helpful and informative case from my perspective to review, particularly for those wishing to obtain or indeed prevent pre-action disclosure of such reviews or reports concerning the wider functioning and quality of specific healthcare providers or settings beyond the perspective that one can obtain via the notes of any individual patient. And what we're then going to go on, once we've looked at that, to explore is transparency and phishing expeditions. We'll explore how and to what extent there are limits on obtaining transparent disclosure imposed by the principles of proportionality, particularly within the pre-action context, that have long barred phishing expeditions. And then finally, we will consider how the courts have tackled the very difficult issue of the conflict between patients' rights and the rights of third parties to confidentiality. So there's very much three sections to the next part of the talk. Moving to a discussion of Hill. So candour and transparency versus safe spaces and how the courts have dealt with this issue. Now, there's some really helpful guidance in Hill. Just to set out the background, some of you may be aware and some of you may not, but the background, Hill involved a Freedom of Information application by a journalist. Now, he was seeking full copy of a 2017 review by the Royal College of Obstetricians and Gynaecologists into a North Devon Healthcare NHS Trust maternity department. The review had initially been requested following a series of clinical incidents, and the application itself was for a full copy of that review. They had the summary, but they wanted the whole review, save for redacted names of staff and job titles. That was what the request was for. And the initial request was refused by the Trust, relying on the exemptions of Section 36 of the Freedom of Information Act. And what that says is that disclosure would inhibit frank and free exchange of views or prejudice the effective conduct of public affairs. And initially, the Information Commissioner agreed this position. However, then we moved to the appeal. Appeal to the First Tier Tribunal. It was accepted that there were strong professional and cultural forces encouraging those within the Trust Maternity Unit to cooperate with any inquiry and work to improve care. And what they said was that the evidence of the report itself showed that although some staff were demotivated, staff at all levels were in fact engaging in the review process. They said professional standards, so the codes of conduct I've already referred to, would drive professional staff to discharge their professional obligations conscientiously in any event to improve care. Now that is one way of looking at things. Some people might see it as framed potentially a little bit more optimistically than perhaps real life might allow people to enjoy. The court then went on highlighting that in this case, it wasn't the first time, now this is really important, it wasn't the first time in which similar concerns had been raised. The First Tier Tribunal highlighted that some concerns in this 2017 review were the same as those raised in 2014 and 2015. And it was in that context that the public policy interest in disclosure outweighed the need for this safe space to drive organisational change. Here it was held that the Trust had had a safe space for several years. It had had ample opportunity to move forward within the protection of that safe space, but had failed to do so. And the public interest, it was held, in understanding these difficulties of the Trust Maternity Unit was substantial. The difficulties, it was said, had gone on for too long, and the public interest in disclosure of the report at the start of 2018 outweighed any likely good that protecting the safe space could achieve. Now, what principles might we then take forward from this into our own practice? I think it's important to highlight that Hill really isn't pure authority for disclosure in all circumstances of this type of report. It would seem that requests for full copy of these types of report might meet, to my mind, more opposition on public interest grounds, where, for example, the report is recent, such that there has been a limited time period available to implement consequential change, and perhaps more tenuously, concerns a historic change has been affected and then not repeated. Conversely, looked at from the other perspective, reports of the type found in Hill that form part of a series, even a series compiled, even a series compiled by different bodies, as we have here, will perhaps be more likely to be in the public interest to disclose. Okay, I will slow down, I promise. Now, moving to consider the second area of culture clash. So between the transparency driven by the move in the health arena towards candour and the fishing limits imposed pre-action by the need for proportionality in pre-action disclosure obligations. Now, the fishing limits primarily derive from the overriding objective and CPR 31 disclosure rules. You'll note that we move from within the health context with this more automatic, wide-ranging disclosure to court-controlled disclosure. In the legal context, there are limits on standard disclosure under CPR 31.6. There are also limits on the duty of search under CPR 31.7, and there's this ever-present overarching principle of proportionality, which is always also in play. Kriti will now highlight some of the most important parts of this legal framework as it applies pre-action in a clinical negligence context.
Thank you, Sophie. Great. So we know that most of you deal with the pre-action protocol pretty much every day, but we just wanted to highlight a few sections from it that we think are really key. The first one is the objective here, the objective C, that the purpose of the protocol includes ensuring that sufficient medical and other information is disclosed promptly by both parties to enable each to understand the other's perspective and case, and to encourage early resolution or a narrowing of the issues in dispute. So very much not a fishing expedition. And then the second one is this section here, 3.2c. Now, I think this is often forgotten, but any request for records by the claimant should include a request for any relevant guidelines, analyses, protocols, or policies and any documents created in relation to an adverse incident, notifiable safety incident, or complaint. So claimants really should be requesting these. They're expected to under the protocol. And similarly, defendants, when making requests for disclosure, for example, from other defendants or other healthcare providers who may have treated that claimant, that exactly the same principles will apply. Now, the test for orders for disclosure before action, this is under CPR 3116, and of course it's a two-part test. So there's a jurisdictional aspect and there's a discretionary aspect to the test. And I'm putting up the wording of CPR 3116 now. So you'll note, we've set out the section for you, but you'll note that the may has been very much highlighted in purple and underlined very much. That shows the discretionary part of the test, and everything else that we've emphasised there is the jurisdictional part. So the court must be satisfied that these requirements are fulfilled before considering whether or not to exercise its discretion to make the order. So the court must be first satisfied of the fact that the respondent is likely to be a party, applicant's likely to be a party. If proceedings had started, the respondent's duty by way of standard disclosure under 31.6 would extend to the particular documents that have been requested, and that disclosure before proceedings have started is desirable for one of the aims set out there. And once those requirements are fulfilled, then the court may or may not make an order. Now, as far as the question of likely is concerned, now there's no requirement for the applicant to establish either that proceedings are likely to be issued or that there is a real prospect of success. It's very clear on the authorities that this provision of the rules doesn't require the court to undertake a full examination of the merits of the case. So it's sufficient for the applicant to demonstrate a prima facie case of entitlement to substantive relief.
Right, so we have established we're likely to be a party, the other side are likely to be a party, and disclosure is desirable for fairness, resolution of proceedings, or to save costs. So the main part of the jurisdictional aspect of the test. Now, the final part of the jurisdictional aspect of the CPR 3116 test is obviously that an applicant for pre-action disclosure must show that it is more probable than not that the documents sought are within the scope of standard disclosure should an action commence. Now, this is a tighter test than is sometimes appreciated. Often parties argue in correspondence about whether documents are relevant. But actually, under standard disclosure and under the standard disclosure test, the test is not simply relevance. The seeming central thread of obsession with relevance is understandable, though, because if we looked at pre-CPR days, the test was formally, hence the slide, as per the Victorian contractual case, Peruvian Guano, and rather wonderfully named. And the test was that any document relating to any matter in question was discoverable. And the courts took a very wide view of what was covered by that. Now, that worked when the test was laid down in the 19th century, when no one really held the quantities of documentation created by digitalisation that they do now. Instead, this has been exchanged for the standard disclosure test at 31.6, which offers much less fertile ground for applicants. Now, here is the test. The test sets out that standard disclosure requires a party, and we all know this well, to disclose only the documents on which he relies and the documents which adversely affect his own case, adversely affect another party's case, or support another party's case. And also the documents, and this is really important in clinical negligence because there's quite a list of documents in the pre-action protocol which he is required to disclose by a relevant practice direction. Now, what's not here? What documents don't need to be disclosed? The test, you'll note, never uses the word, well, it does use it once, but doesn't use the word relevant in relation to the documents, except it says relevant practice direction. Documents relevant to the issues in the proceedings, but which do not obviously support or undermine either side's case, are not prima facie disclosable without further order for enhanced disclosure. You're not going to get that at the pre-action stage. They're part of the story or the background. Also not here, and this is quite important, are what are known as train of inquiry documents. So documents which may lead to a train of inquiry enabling a party to advance their own case or damage that of their opponent, but which aren't in themselves either relied upon or adverse to either side's case. Again, enhanced disclosure is what you might require in appropriate cases for that type of disclosure. So what impact does that limitation have in practice, we ask ourselves? Now, within a clinical negligence context, obviously there are many pre-action protocol documents, many documents required for the drafting of our very detailed letters of claim, letters of response, and indeed the pleadings themselves. And a lot of these do naturally fall under the pre-action protocol documentation list, so they will be automatically disclosable. However, where pre-action disclosure isn't forthcoming or where there are further documents that are considered relevant that haven't been provided, and where details of the case and perhaps those documents that might be available are still relatively unknown at the pre-action stage, it's really important to be quite careful to limit pre-action disclosure applications to really focus down on the issues in the case, as the court is very, very unlikely, given what the test is, to be receptive to. And we've all had cases where they would be hugely critical of a very generalised or insufficiently specified applications. So some applications that have I've come across in previous years have perhaps taken from a pro forma list, etc., and judges can be very hostile towards applications that appear as if they haven't been specified to that particular case. It's also vital to note that it might well be, in any context, important to stage disclosure. Do it in tranches as your case evolves. And with those tranches of disclosure, there may be time to regularly review and see whether and where further documentation might then be appropriately requested. And then you've got a basis in your case to request that documentation. And timetabling those types of regular reviews, I think, are quite important, given how prolonged the pre-action stage in many cases can be and how much cases can evolve over time. That may mean that further cases are drawn into the net. Now, what we then end up with, to my mind, is an initial request, initial pre-action disclosure request that perhaps one could say is, and I've labelled it relevant light. It's not that these documents are irrelevant. It's just that there are documents that could arguably be relevant, but that don't fall into this particular list. So what it does is it avoids background documents. and it makes no mention either directly of train of inquiry or in another alternative phraseology of words equivalent to "we want to see these because they might lead on to something else," etc. Type of inquiry documents. And what it does is it focuses very heavily on the issues in the individual pleaded case in terms of the pre-action disclosure application. Because although pre-action cases are as yet unpleaded, to my mind, it's really relevant to consider what would be within the pleaded case. So one helpful practice point actually that I found in the recent High Court decision in Johnny Depp and News Group newspapers is where it states that whether a document fell within standard disclosure is to be judged against the statements of case and not by reference, for example, to matters that might be raised elsewhere, including in witness statements. So it's very much focusing down on what your statement of case would be, what would your pleadings be in order to guide you as to what documentation is likely to be allowed for disclosure at that very early stage. Some further practice notes in responding to such applications that you might wish to bear in mind, you probably already do, is that you're not disclosing background and train of inquiry documents, and that it is also permissible under the White Book notes and case law to mask irrelevant parts, for example, of a document by way of redaction. And also disclosure of documents related to non-material allegations, which even if substantiated would not affect the result, you can avoid disclosure of those documents as well. So if they're non-material allegations, they don't go on to affect the result, you don't have to disclose those documents. Now, so let's assume under a pre-action 3116 application that you've established the jurisdictional basis upon which such an order may be granted. It then needs to be remembered, as Kriti already highlighted, that the granting of the application still remains very much within the court's discretion. Now, how might this discretion be exercised? There's nothing actually in the rule. It just says may. The court may make an order under this rule only where the jurisdictional basis is satisfied. So we then look at the case law. What does the case law say? Now, the case law I've set out there's some very contrasting approaches. There remains an emphasis, particularly in the commercial courts, under case laws such as no-star shipping, to carefully circumscribe the documents or classes of documents sought and to limit applications to what is strictly necessary for the just disposal of any case. However, this approach strongly contrasts with another approach that I've highlighted in the case of Dunn and Durham, taken in this more recent Social Care Court of Appeal case. So moving to look at what Dunn and Durham said. Now, in Dunn and Durham, the claimant alleged he'd been assaulted by staff at a centre for young people run by Durham County Council. The documents were disclosed with names of service users and staff removed. And in ordering disclosure of the unredacted documents, the Court of Appeal held that, firstly, it was unfortunate that the dispute about disclosure had been prolonged and distorted by references to the DPA. It was said, for litigation purposes, obligations in relation to disclosure only arise when the relevance test under the CPR Part 31 has been passed. However, they emphasised, and I know I'm now using the word relevance, but it was used by the Court of Appeal, but it's a very specified, constrained form of relevance. It was emphasised that once the applicant has established relevance, that the onus is then on the respondent, and set out in the slides, the onus is on the respondent to show why disclosure shouldn't be given. And more than that, the respondent must then prove that denial of disclosure was strictly necessary. And that would involve, as it did here, balancing the Article 6 right to a fair trial against the right of an opponent or non-party under Article 8 to privacy and confidentiality. I think it's important to note actually that it might not be appropriate to accept or anticipate that this type of Article 6(8) balancing act will arise in every case. For example, if you take a case where professional information regarding clinicians is contained in medical records relating to the treatment of the applicant, those will not be personal records but professional matters and not falling under Article 8. Where we start to stray beyond that though, where we're talking about personnel or training records of clinicians, then obviously a very clear argument needs to be made out balancing these rights, a clear argument about the relevance. Or where, for example, they concern other patients. So if you had a question over for the prioritisation of or length of a queue for theatre, you might be easily able to limit Article 8 issues in that case even. So even there, you might be able to limit Article 8 issues by anonymisation or redaction, and by protection of those identified in the documents with carefully drafted orders limiting the use of those documents. And Kriti is going to go on to discuss that later. So that's Dunn and Durham. The further potential arguments as to where the limits of disclosure are drawn are those surrounding legal professional privilege, public interest immunity, and third-party confidentiality. Now I'm noting the time, so we're going to go through those reasonably quickly. What we have is under legal professional privilege, obviously there are two categories of legal professional privilege, which you'll all be aware of. So documents are either privileged under legal advice privilege, even though no litigation is contemplated or pending. So we're talking about communications passing between a party and their solicitors for the purpose of legal advice. So those are privileged. And then we have that second subset of documents, those documents or communications between a solicitor and a third party that are privileged only if litigation was contemplated or pending when they were made. That key question in relation to that latter group we've put on the slide is, in summary, whether the documents were prepared for the purposes of obtaining legal advice or in contemplation of litigation. And what you need to look at in any case is what is the dominant purpose of the document. So, as in the case of Lask and Gloucester, disclosure was sought of an accident report form. Now, the report in Lask was found by the court to have been prepared because it was required for the purpose of preventing future recurrences, but also for the purposes of informing future litigation. And it was reaffirmed in Lask that legal professional privilege doesn't apply where the legal advice purpose is simply dual rather than dominant. Obviously, the primary founding case law for that being War and British Railways Board, which I've put on the slide as well, just for your reference. So now Kriti is going to discuss public interest immunity.
Thanks, Sophie. So the second potential. Hang on, bear with me. And I has someone not muted their microphone? That tends to cause an echo. Let me just check that.
Shall I switch mine off? Will that help you?
Yes, let's try that now. Oh, that's much better. Thanks, Sophie. Sorry. Yes, as I was saying, so public interest immunity is the second key potential limitation on disclosure. So on the CPR 3119, there's a procedure to limit disclosure where it would damage the public interest. But the key question is whether withholding those documents is really necessary for the proper function of public service. However, I think as we've discussed already in relation to the case of Matthew Hill, for instance, the courts have accepted that there's a strong public interest in the production of documents suggestive of or investigating safety issues within the health arena, which potentially that makes it a bit more difficult now to rely on this disclosure exception, particularly in the current climate of the duty of candour, for example, that we've talked about. Then the final restriction that I want to talk about on disclosure of third-party information is one which is of real concern and practical implications, I think, for a lot of the work that we do. So that's the issue of third-party confidentiality. So quite simply, you can't disclose third-party information without the permission of that third party or a court order. So we might need to think about the types of third-party information that's likely to be involved in a clinical negligence case. So, for example, if you've got an entry in the records that says, for instance, claimant's sister Jane attended with her, she said husband Ben did X, Y, Z. Now, the fact that the sister is called Jane and the fact that the husband is called Ben and he did X, Y, Z, all of that is already known to the patient or to the claimant in this case. So you're not going to be disclosing the other person's information in a way that's unacceptable. But consider, for example, records instead on a ward that say name of Susan in the next bed also had the same infectious condition. Now there's a risk that you're going to be disclosing that information if you leave that bit unredacted, for example, or if you hand those records over as they are, because you're letting the person know that there was someone called Susan who also had that infectious condition. And then similarly, where there's a request for the training records of clinicians or other personnel records of clinicians, again, there's a need to balance those rights against the need for disclosure. But despite the limitations requiring the person's permission or a court order, third-party confidentiality has still been held by the courts not to provide a standalone ground for withholding disclosure. So it's a relevant consideration, and as we discussed when we were discussing Dunn and Durham, as far as the court's discretion is concerned under CPR 31, but there will still be the same balancing exercise by the court of the third-party Article 8 rights against the applicant's Article 6 rights. So we're going to go through some examples now. Won't take too long over them. Right, so I'll put my microphone back on. Disclosure of medical notes relating to any particular individual. Obviously, these are likely to be relatively uncomplicated given that there's statutory right to these in any event, and we've covered those various statutory routes right at the outset. However, as Kriti has just highlighted, there's a real need to review for third-party names and details and to think about their relevance to the issues involved, whether or not they could appropriately be redacted if not relevant, whether or not there's any Article 8 infringement, and how that then balances against the Article 6 right to a fair trial. And obviously, in any case, if permission isn't given by the individual, you will need a court order to disclose. Third-party notes pose their own issues. The same issues arise. You definitely need permission or a court order. And you need to very carefully consider where third-party notes are being requested, their relevance. And Kriti, I think you have a very good example of relevance being made out. Yes, so I had a pre-action disclosure application a couple of years ago where the claimant was a carer at a care home for adults with severe learning disabilities. And on a night shift when she was working, she was assaulted by a service user that she was supposed to be looking after. Now, the key allegation that was being made on the claimant's behalf was whether on the night shift that service user needed additional support. So whether she should have been assigned, for example, 2 or 3 or 4 carers on the night shift rather than just the one. So in order to pursue those allegations properly, disclosure was requested of that service user's medical records insofar as they were relevant to that question, and disclosure was ordered, but it was limited only to those medical reports which answered that question. So how much care was required by that service user, particularly overnight, and it was limited to a certain time period, and it was limited in terms of the purpose for which those records could be used. And of course, the name of the service user was anonymised because there was no justification for her name to be disclosed at all.
Right. So moving to another type of document, investigations documents, complaints types of documents. So serious incident review documents or an investigation arising out of an index event. Now we note that the protocol is highlighted by Kriti, and the particular passage of it is already in the earlier slide, expects disclosure of background documents upon which some of these have been based. The GDPR also to some extent expects disclosure. It doesn't appear that there would be a very good argument for privilege where the serious incident review is concerned, because when you look at the purpose of the document, we look at the subtitle of the serious incident framework. The actual subtitle is supporting learning to prevent recurrence. So you'd be running very strongly up against LASK and that it's a dual purpose rather than a dominant purpose in terms of any litigation. The report is prepared because it is required for the purposes of preventing future recurrences. However, where, for example, we're talking about wider investigations, so investigations, for example, into hospital management of infection or the running of a unit, then we need to be considering whether it is relevant to the issues in the case and how circumscribed and focused we might be able to make that. And it may well be that, as in Hill, that it will be possible to argue that disclosure is within the public interest. But as Kriti has highlighted in reference to that example case, again, the importance of remaining aware of third-party confidentiality issues and careful work to redact out non-relevant third-party information and to either obtain individual permission or court permission for the disclosure of that information is required. So that's investigations and complaints. A third type of document that we'll come across quite a lot, or type of documentation really, are documents that talk to issues around systemic negligence. So, for example, where there is an alleged failure to scan someone to operate within a guideline time frame, where, for example, the defence is that a trust was unusually busy on a given day, and all of the documents that surround that. And one can imagine the extent of disclosure that can often surround investigating these types of issues. What then needs to be focused down on is what supports or adversely affects the case, and also the proportionality of any search in relation to the usual factors, case value and importance of the case, and also the public interest. The final thing that you need to bear in mind, or the sort of dual thing, are these Article 8 risks to privacy and confidentiality. And again, the role of redaction in limiting documents down to those relevant issues, those pleaded issues within the case. Again, court order for third-party information. The other thing you can do, and of course should be doing in all cases, and Kriti will go through this, is draft within your order an order limiting the use of those documents for onward purposes. Now, moving to the clinician's personnel file, where a personnel file is being requested, and we've all made and met those requests, the extent to which any aspect of the file, training, performance, disciplinary, health, actually goes to an issue in the case or is necessary for the just disposal of the case needs to be really focused in on. The answer, of course, may not be the same for all aspects of that file, and the court emphasises the need to carefully consider the role of redaction and whether there are genuine, and there may well be, particularly if one were considering health issues, etc., Article 8 issues to balance against the claimant's Article 6 rights. And I think at this point it's very important to highlight that when clinicians' records are being requested, there needs to be preparation to justify why they're being specifically required in the particular case as against the pleaded or what will be the pleaded case. Kriti.
Thanks, Sophie. We're almost done, I promise. I need to end with some warnings. So the first is the point that Sophie mentioned just now, that the pre-action protocol used to contain a paragraph saying something on the lines of, any document received under this protocol can only be used for these proceedings. That paragraph now appears to have gone. I don't know why it's not there anymore. So defendants or respondents, when giving disclosure, need to make it explicit that that disclosure is being given only for use within those intended proceedings. So, and the same applies, of course, when claimants are providing disclosure to defendants of other health records that they hold, for example. So there isn't an implied collateral undertaking anymore. So you need to give explicit notice to applicants when giving disclosure. And then finally, we come up against everyone's favourite topic, and of course what you've been dying to hear about from us, which is costs. So there's a presumption under CPR 46(1)(3) that the court will award the person against whom the order is sought their costs of the application and of complying with any order made. But the court is entitled, as a matter of discretion, to deprive that party of its costs on the basis that the application has been unreasonably and unsuccessfully resisted. And we come up against these arguments all the time, particularly in pre-action disclosure applications. So where an applicant has made a pre-action disclosure application and they've been partly or wholly successful, you can expect the court to scrutinise very carefully the extent to which that applicant was successful. So if they asked for 10 items and in fact the court has ordered most of them or almost all of them, then they've been largely successful. The reasons for the respondent's refusal up to that point, and the manner in which the refusal has come about up to that point. So it's really important, we would say, to have clearly set out in open correspondence in the run-up to your pre-action disclosure hearing for both parties, both the applicant and the respondent, to set out why the applicant wants all of the documents that they do, so properly explaining how they are relevant to your case, what exactly they want, why the respondent believes that they're entitled to refuse to disclose those documents. For example, if they're saying we don't have them, or these are records owned, prepared by clinicians at another trust, for example, or that these are third-party records and that we believe the applicant should be making an application to court and we will be neutral on that application because it's not for us to disclose those records otherwise. So all of those principles, I think, need to be set out really clearly in your pre-action correspondence before you get to a hearing in order to not be hit by the adverse cost consequences. I can see there's a question in the chat. So what application should be made to the court if the defendant does not comply with a pre-action disclosure order? If we apply for an unless order, can we ask for judgment to be entered for the claimant when we are at the pre-action stage in the event of further non-compliance?
Now, I've had this.
Yes, go on, Sophie.
Yeah, I've had this happen. What one normally does, or what I would normally do, is it's not an unless order in terms of judgment on the case. What you would normally do is ask for an order that if they disobey the judgment or order, etc., then that may be enforced by an order for committal, for example. So effectively they end up in contempt of court. So that's one way of doing it. And that seems to work quite well. People jump quite far when you do that. So that's probably one way of doing it. I don't know if other people have other approaches that they've used in practice. Perhaps they'd like to share.
I know. I think that I agree. That's very sensible, and I would hesitate to go straight from non-compliance with a pre-action disclosure order to judgment being entered. I think what you want to do is very clearly let the respondent know that you're going to be going back to court for committal proceedings and for costs if they continue to refuse to comply. And hopefully that will motivate them to do so. If not, then you have the option of going back to court to get enforcement of the order. There's a further question. What if it's a company defendant, though? Who do you commit?
Now, in terms of a company defendant, I think that I'm just having a look just to check that I'm going to give the right answer on this. Let me just, it's usually, if that person, against any director, it's usually directors that want, or committal for breach of order or undertaking, yeah, which is alleged to have been taken place. Yes, you'd usually be, I think, aiming at the directors of that company where you're looking for committal on those basis. Is it
James has also
James?
Say, yeah, it's the director or other officer of that company. Thanks very much.
That's very good. Thanks, James.
Any other? I hope that's answered your question so far. Oh, thanks, James. I hope that's answered your question so far. Any other questions for us? I think we're done in terms of the substance of our talk. I appreciate we've covered a lot of quite dry ground, but do feel free if there are any other questions or any points you want us to think about or discuss, then now's the opportunity. I think, Sophie, we can take that as a oh, what if it's a charity?
Oh, I wonder, trustees? James, you are in front of your white book right as we speak.
My instinct says trustees for a charity. James is taking the opportunity to head off. Yes, I think trustees for a charity. Local authority. Now that's an interesting question. Who would be enforcing? Who'd be going after to enforce for a local authority?
You might then have to look at some kind of financial penalty to encourage production.
Yeah. But yes, and wasted costs. Well,
yeah, exactly.
Because if you're
get them along to explain.
Absolutely, because if you and your local authority, they might, for example, be represented by in-house legal teams, for example, and if they fail to set out up to that point what's going on and why they fail to comply, then certainly making it very clear that you're going to be pursuing them for a wasted costs order might get the ball rolling a bit quicker, and then if push comes to shove, to make an application for a wasted costs order and get an order for them to show cause, and if nothing else motivates them, hopefully that will. So thank you. Any other points for us to discuss, or we will let you go? How could one seek judgment when, by definition, the application is for pre-disclosure?
That's why you can't go down that route. That's why you end up going down the committal route in terms of enforcing the order made by the court, because the pre-action disclosure application is still for a court order and that order still remains enforceable. So that's why you can't go in the other direction. But thank you, Mark. Yeah, that's why.
Okay.
Terrific. Well, thank you everyone for your time today and for listening in. We really hope that you found this informative, helpful. It's going to be available online, so you can have a little listen again if you so elect to do so. But from Kriti and I, thank you so much for your time.
Thank you, and good afternoon, and we'll let you go and hope you all have a lovely evening.
Thank you. Bye.